Recent legal developments in Nigeria have sparked significant discourse regarding the internal dynamics of the People's Democratic Party and the federal government authority during emergencies. The Supreme Court's reinstatement of Senator Samuel Anyanwu as the PDP's national secretary has raised questions about the judiciary's role in party affairs and the implications for party leadership structures. Concurrently, President Bola Tinubu's declaration of a state of emergency in Rivers State following incidents of pipeline vandalism has led to debates about the constitutional processes involved, particularly the National Assembly's endorsement and the legal procedures required for such proclamations. Now, to provide expert analysis on these issues, we are joined by legal practitioner Kenneth Okonkwo, who will elucidate the legal ramification of the Supreme Court's decision and the constitutional considerations surrounding the emergency rule in Rivers State. Good afternoon, and thank you so much for joining us on Newsday.
Good afternoon, and thank you, viewers, for joining us.
Now, let's start with the implications of the Supreme Court's ruling on the legitimacy of the National Secretary elected by the PDP. What are your thoughts on this?
Well, what I understood the Supreme Court said is that internal affairs of political leadership belongs to the party, not to the courts. And I think that's really very welcoming, because we do not need more judicial intervention in our democratic process, especially the internal working of political parties. We need less of it. This is not judiciocracy. Judiciocracy is my own word to say government by the judiciary, but the actual word is critocracy. We are not in a critocracy. We are not in a government by the judges, but I use the word judiciocracy, so I will bring it home that I'm talking about judiciary. So we do not need more intervention of the courts in our democratic process. We need less of it. So if the Supreme Court said that the courts do not have jurisdiction to dabble into the internal affairs of political party, I support it. So in this case, they said the case is not justiciable. I wonder who is saying that the Supreme Court said it's Anyanwu or it's Udokoye. Sorry, my understanding is that the Supreme Court said that it is PDP that should decide who their national secretary is. And once the PDP decides it, so be it. The Supreme Court is saying, sorry, we are not the ones who should come and decide for you who should be your leader. And as a matter of fact, it's very sound, because Section 40 is very clear. Everyone is entitled to assemble freely and to associate with others, in particular to form or belong to a political party, trade union, or any other association for the protection of his interest. So a party is supposed to be a conglomeration of people who have common interest, and they should be able to sort out their problem. If they're not able to sort out their problem, please, they should dissolve and not bring in their manipulative tendencies to the judiciary to cause problems for both the judiciary and for the polity. So my understanding is that Supreme Court said they don't have jurisdiction to dabble in the internal affairs of a political party. So whoever the National Working Committee or National Executive Committee or National Convention decides that is the National Secretary of PDP, so be it. So I'm not aware the Supreme Court said it's either Anyanwu or Udokoye. The Supreme Court said PDP should be able to sort out their problem and leave us alone.
The Supreme Court definitely washed their hands of this rather muddy mess that the PDP finds themselves in. But to what extent, after having seen this play out, does this decision set a precedent for any future intra-party disputes that the courts might need to handle, particularly considering leadership positions? And are there any other potential legal challenges that could come out of this ruling?
Now we see why I said it's a beautiful thing. Because the Supreme Court has come under terrible bashing for certain judgments they have given. And it's quite wise of them to begin to relieve themselves of the manipulative tendencies of the Nigerian politician. So the implication is that the parties should learn to sink if they cannot swim. And they should learn to carry their problems inside and be matured enough as mature adults to sort out their problems and not trying to use the courts to undermine democracy and undermine each other. People who have common interests should come together in a common manner to sort out their problems and choose who their leaders are. The implication is that a party should be able to decide on what to do to lead themselves and leave the courts alone. It's a beautiful thing. Swim or sink. Simple.
Well, very well said. But then I'm wondering, what reforms or changes do you think will be necessary to prevent similar conflicts in the future and to prevent parties from running to the courts all the time?
Simple. Just like President Goodluck Jonathan said, they are simply pretenders. They are not contenders to the efficient implementation of their own constitution and rules. They know what to do. Their laws are there, which they enacted and gave to themselves. They should simply obey the laws and the rules of their party, the way they wrote it, and stop trampling on it and trying to use the court to undermine their own constitution and their own rules. In Nigeria, people know what to do. I've always said, laws are not our problems. We have sufficient laws. It is rule of law that is our problem, which is equal subjection of everybody without discrimination to the supremacy of the regular laws, and the government doing every action in accordance with the law. So they should learn to obey their rules, and they wouldn't have problems at all. It is lawlessness that is bringing anarchy to the political parties. Non-respect for internal democracy or political parties, as stated in their constitution. Simple. Learn to obey your rules, your constitution, and you won't have any problem whatsoever. And there will be orderliness in your party.
And speaking of obeying the Constitution, let me pivot a little bit to another story that's been dominating the headlines, as it seems everyone these days has now had to become some form of a legal practitioner to decipher what's going on, especially in Rivers State. Now, some legal analysts are stating that President Tinubu's proclamation of a state of emergency in Rivers State last week and his suspension of the elected officials constitute a clear overreach of executive power. Neither Sections 305 nor Section 11 of the Constitution grant the president the authority to take such actions. So to speak some more legalese for us, Mr. Okonkwo, can you give us your assessment on the constitutionality of what played out in Rivers State?
Right. I want to start with this. A lot of people have been making a mistake saying the National Assembly approved what President Ahmed Bola did. Sorry. Strictly speaking, they rejected it. They did not approve it at all, strictly speaking. And here is the point. The Constitution is very clear. Section 305, subsection 1, said the president can issue or declare a state of emergency in a proclamation that is stated in a gazette, meaning the proclamation issuance is complete with the president before going to the National Assembly. In subsection 2, the Constitution said the president should transmit copies of already published, already proclaimed state of emergency with the details of the proclamation to the National Assembly for the National Assembly to approve or not approve. Here is the point. The details of the purported proclamation of state of emergency by Tinubu is that he is suspending the governor of Rivers State and the House of Assembly members, and that the sole administrator whom he has appointed, one Ibok Ete Ibas, a military man, you can put retired if you want, that the man will make laws and he, Tinubu, will be the one to approve of the laws. And when he did that, it was published, it was proclaimed, it was complete. When it came to National Assembly, their duty is either to approve it and the details, and I'm talking about Section 305, subsection 2, or reject it. they don't have any power whatsoever to amend it, because it is not a bill as contemplated by Section 58 or an appropriation bill as contemplated by Section 81. These are bills which the National Assembly have the right to amend and before it becomes an act. But in a proclamation of a state of emergency, it is already completed as a law, gazetted and published before going to the National Assembly. So the role of the National Assembly is to either accept or reject. Now, what did the National Assembly do? They selfishly recovered their own power from the president by force, because not by law. They say, Mr. President, you don't have the right to make law for Rivers State. The right belongs to us. So they purportedly said they amended it to recover their own power. Sorry, you have already rejected the entire state of emergency, because it's either you accept the proclamation and the details or you reject. That is what the law says. And let me come again to it. Section 58 of the Constitution made it clear. Section 56 of the Constitution made it clear that the House, the National Assembly, if there is any question that comes for decision, they can approve it with the required majority. They use the word required majority of those present and voting. In this case, by Section 305, subsection 6b, the required majority is 2/3. And the National Assembly does not have the 2/3. And they showed it openly. If they had it, they would have told us about it. 2/3 is not measured by voice vote. Why? They said those present and voting. Did you see when the Speaker of the House was talking? They did not show the members who were even doing the voice vote. They showed only the Speaker. You know why? They don't have the required majority. And now, they said present and voting. The people that have absented themselves from voting, how many are they? Because you can be present and not voting. How do you determine that? By voice vote. So sorry, there's nothing like voice vote. When the Constitution said 2/3, you must tell us the number of people present and show it to us. You must tell us the number of the people that voted and show it to us. You must tell us the number of the people that absented from voting or abstained from voting. You will tell us. And the people that voted against. None of this is determinable by a voice vote. I am making a negative assertion that they did not do anything, and I have nothing to prove. They that are making the positive assertion in law are the ones that have the onus to prove that they secured the 2/3 majority. That has not been approved. So both in substance, by which they amended the state of emergency and cherry-picked the one that concerned them, they have destroyed the state of emergency. There is no room for amendment. It is just like taking a law to the president by the National Assembly, and the president, when he wants to assent to it, say, no, I don't like Section 2, I'm amending it. After amending it myself, I will sign it. No. So the Constitution did not give the National Assembly any right to cherry pick the one they want and leave the one they don't want. It's either they are accepting all or they are dropping all. Having cherry picked, they rejected the entire state of emergency. Let me talk about the legality or constitutionality of what President Ahmed Bola Tinubu did. Sorry, he did not declare state of emergency in Rivers. He declared martial law. What he did was a coup against the Rivers people. The Constitution is very clear on how you elect the governor. Section 179, Section 180. And how governor is removed. Section 188, Section 189. And the law is very clear. How you elect the House of Representative members, which is there, and how you remove. Section 117 and Section 110. Clear and simple. It is by election, by the people of Rivers State. And you want to remove is by death, resignation, removal by impeachment, permanent incapacity, or in the case of the House of Assembly members,
Mr. Okonkwo,
recall. This is what these places did. So the president simply suspended the provisions of this constitution, including Section 1 and Section
Mr.
1, 2,
Okonkwo,
which said you cannot govern Nigeria or any part of it by any set of people except in accordance with the Constitution. So appointment of sole administrator is alien to our Constitution, not contemplated. So what the president did was a martial law. It's unconstitutional, it is illegal, and it is criminal, because that is the real treason we are talking about. Usurping the power of the National Assembly to make law for Rivers State is another treasonable offense. Now, destroying and giving money, unappropriated money of Rivers State to a sole administrator to spend as he likes is another treasonable offense. And I will give you why. As I'm talking to you, there is no 2025 appropriation budget for Rivers State. None. The Supreme Court has already said that there is no appropriated bill or law for Rivers State. That's why they said Governor Fubara should represent it to the House of Assembly.
But I have to, for the sake of time. You know, right now you've said that, in your opinion, you believe that the president's action is treasonable. But we do know that in the past, we've also had declaration of state of emergency in some states of Nigeria. So I'm wondering what lessons can be learned, you know, from past experiences with emergency rule in Nigeria, and how can those lessons influence the current situation in Rivers State? Very briefly.
Good. Like what you said, Goodluck Jonathan declared emergency rule in 3 states of Nigeria, Borno, Yobe, and Adamawa. He did not remove the elected representatives of the people. That is state of emergency. But what Tinubu did is a martial law. Now, because he removed elected representatives of the people, not in a manner anticipated by the Constitution. Tinubu also gave money to the sole administrator unappropriated. So in future going forward, any president who wants to declare a state of emergency must fulfill Section 305, subsection 3. When Tinubu was saying he had a security report, they should read to him Section 305, 3D. He said there must be clear, not obscure, clear and present danger of actual breakdown of public safety and public order in such a manner that requires extraordinary measure. Clarity means open, objective. When you say there is danger, there is nothing like security report. That's a subjective report given to you by your appointees, whether National Security Advisor or anybody, which is known by you alone. So there is nothing like security reports as a standard to declare state of emergency. Have you contemplated if you allow that precedent? Any president will come and tell you, no, don't question me. There is a security report which only me knows, and I can use it to remove every governor and take over the administration of the state.
Kenneth Okonkwo.
That is why I said it's treasonable. So going forward, no president has the right to declare state of emergency and remove elected representatives of the people. When you want to declare state of emergency, you have to empower the democratic forces to be able to tackle the problem, not remove them.
Very well said. Very well said.
It is the federal government that has the exclusive power over armed forces. The state do not have state police. So if it's any issue of security, it is the federal government that has the duty to take it out, not the state. So if the federal government is failing, they cannot.
Mr. Okonkwo, I really have to jump in now because we have run out of time. And honestly, we very much appreciate you, putting in very clear words the exact situation as it plays out. And we appreciate you always coming on Newsday and speaking with us. Thank you so much, Kenneth Okonkwo, lawyer.